Okay, well, hi there. Let's get started. So hello again. Welcome to the masterclass. Today I'll be sharing over 30 years of advising employers on how to strip down to one legal system to eliminate employee wage and hour lawsuit risk. Okay, now before we get started though, I'm a lawyer, so I have to give you a disclaimer, right? So the information that we cover on this webinar is for informational purposes only. Okay, it should not be implemented without the advice and counsel of an experienced and knowledgeable employment and labor law lawyer. All right, enough of that. Okay, so we'll start with a little bit of a role play. Now imagine this, okay, this is you. It's Tuesday morning and you're sitting at your desk. You're called to reception and you're greeted there by a stranger. Turns out it's a process server, hands you a stack of papers, okay? As you flip through this stack of papers, you know the feeling, you know, your heart and your breath drop to the pit of your stomach. You know, you can't breathe. You know, as you look through it, you're realizing that one of your best employees, one you treated great, just served you with a multi-million-dollar class action, wage and hour class action lawsuit. Okay, for what? Rest periods, meal periods, silly things, itemized wage statements, things you didn't even realize were problems, right? And now you're staring down the barrel of hundreds of thousands, if not millions, of potential liability exposure. And I've seen countless potential clients sitting where you're at. Time and time again, great people, treated employees very well, worked their asses off, and still, unbelievably, they got blindsided by a lawsuit they never even saw coming. You know, and it drives me crazy because, like I said, for 30 years now, I've been trying to keep all you small business owners out of trouble from this wage and hour stuff, right? So if you've ever had that pit in your stomach, wondering whether you're just one disgruntled employee away from a lawsuit that can absolutely tank your business, then today's for you, right? Stick with me. But first, let's make sure this is actually for you. So who is this for? This is for you if you've ever felt like California law protects your employees, right? But not you. And if you've ever been told, quote, just treat people right and you'll be fine, end quote, by a business consultant or otherwise, this is for you. And finally, this is for you if you're done reacting to problems after they explode and you want to get ahead of problem employees once and for all right? Sound like you? Okay, great. Well, this is for you today. But if you think that lawsuits only happen to bad people, then this is probably not going to land. But you're welcome to stay in any event, right? And by the way, you're badly mistaken, as you'll see from one of the two stories coming up. Okay? And if you enjoy litigation, actually enjoy it and spending time with your stellar litigation team, likewise, this is not for you. Okay? Who here actually likes litigation? Even lawyers don't like it, of course, believe it or not. All right? So here's what we're going to cover in the next 30 minutes or so. But in this session, you'll walk away knowing how smart business owners reduce their liability exposure from wide open to as close to zero as possible while keeping their hard-earned money. Now, this isn't theory. This is a battle-tested legal system that I've honed over 30 years that's helped my clients go from millions of exposure to ending cases dead in their tracks and in 1/5 the time. Okay, you'll walk away today knowing exactly what's leaving you exposed right now and what to do about it. And whether you actually work with me or not, you'll walk away at least with a clear roadmap on how to avoid years of misery and potentially millions of cash outflow losses. And here's how we're going to get there. We're going to cover three things. First, why the best intentions that everyone talks about is only leaving you wide open for a multi-million-dollar legal disaster. Okay, second, we're going to talk about the fork in the road. The fork in the road that most small business owners miss and why it determines whether they pay $20,000 or $2 million when the inevitable lawsuit hits. And finally, third, we'll talk about what the 1% are doing before they ever need a lawyer and how you can do the same, all right? But first, a quick intro so you don't think I'm just making this up. I'm Scott Shibayama, founder of Vision Law Corporation. At Vision Law, we've helped over 300 employees over the last 30 years, from small restaurants to bakeries to service providers, reduce their liability exposure by over 300 million combined. Now, but I've sat in rooms with clients staring down the barrel, 15 million. That's a lot of money, $15 million PAGA class action exposure. Now, I've walked in from the ledge, saved them tens of millions, and resolved their cases efficiently. But I've seen far too many really good people over the years, lose sleep, hear it all the time, lose money. And yes, even lose their businesses because they didn't know what they didn't know, right? Okay, but this isn't about me. This is about giving you a real legal playbook so you don't get burned. Now, how about a quick poll? Who on this masterclass has had a problem employee, right? You have a situation right now. You've had one in the past, or you haven't yet, but that's the point of this webinar, to prepare and avoid it in the first place, right? So make your choice. Meanwhile, we'll get back to the question at hand, all right? So why is it that California employers, much to my chagrin, every day I see it, keep getting burned by this wage and hour stuff, okay? Well, it has to do with what you've been told to do, right? Because here's the thing, it's not bad advice, it's just incomplete advice. And incomplete leaves you wide open. So a couple of, quote, best practices up on your screen, right? First practice, just pay people fairly and treat them well. You'll be fine. Okay, what you'd hope you do, keep your employees happy, avoid lawsuits, and build loyalty. What it actually does, builds a false sense of hope, leaves you completely defenseless when one of those employees you treated really well, right? I hear it all the time. Bite the hand that feeds them. They decide to sue you anyway. Ultra frustrating. Okay, because the thing is, California law does not care whether employees like you. Like I tell all my small business clients, once you've been sued, you've already lost, right? Because you have to spend your hard-earned money paying for your lawyers, and you're exposed to the other side's attorney's fees and costs as well. Okay, so, and that one gap, right? That one gap is the difference between a $15.50 an hour employee and a $1.6 million class action you'll see coming up. But first, just in case, I just want to let you all know, by the end of this session, of course, I'm going to be offering a free legal strategy call with me, okay? So that you can absolutely shore everything up and learn how to avoid all this ridiculous California wage and hour stuff. Okay, so two ways you can book the call. One is to scan the code on your screen. The other one is to click the button below. Pick a time this week or next. All right, well, too early. You guys aren't ready yet, right? You need more information. All right, well, let's talk about that. So I'm going to be telling two stories, both of which are based on actual cases my firm has handled, okay? Names changed to protect the innocent, right? So the first story, one is not so good, one is good. First story, you're looking at a rather somber picture of a bar, okay? We'll call it Lori's Place. Lori, 25 years in business, okay? Business owner, successful, single shareholder, S corporation. Owned and operated a couple of bars. Very loyal clientele, great reputation in the local community. Lori's Place at any one time employed about, small business, 20 regular employees, about 85 over 4-year statute of limitations. Why 4 years? You'll see coming up. Okay. One employee worked for Lori part-time, just 4 days a week, 6 hours a day. So that's 24 hours a week, part-time. Paid $15.50 an hour. Okay. Lori and this employee got along great. They never had any problems, right? As far as Lori was aware. They had great conversations, according to Lori. And Lori even thought this person was a friend, right? Until this employee one day served Lori personally. So she had personal assets at stake and her S corporations with a wage and hour class action lawsuit. Now that's the actual complaint that's up on your screen. It's been redacted, of course. Items 1 through 8, those are the causes of actions or claims. Very typical in a wage and hour case, class action, PAGA, or otherwise. Okay, failure to pay minimum wage and overtime, usually based on working off the clock claims. meal period violations, rest period violations. Okay. Failure to provide accurate itemized wage statements, and waiting time penalties. Some of you on this masterclass may have heard these terms before, right? Hopefully not you personally, but maybe through some of your colleagues, right? So when Lori came to us, of course, like everyone, they're shocked. They're in a state of shock. They're pissed. And in Lori's case, she was heartbroken. Why? Because she couldn't believe this person who she considered to be her friend, right? Who she treated so well, would do this to her, would sue her. And Lori couldn't even begin to understand how she could be liable for this stuff. She swore to me over and over. What do you mean? I paid her all her wages. She got all her breaks. She was a smoker. She was constantly on break. And I paid them for the meal periods. They ate my food. Okay. So I sat down with Lori. I asked her, great, well, we're here to defend you. Do you have written policies on timekeeping, rest periods, meal periods, overtime, things like that? Unfortunately, Lori didn't have that. Nothing in writing regarding these wage and hour policies. So then I asked Lori, well, how about daily time records? Surely you have those, right? Can you give those to me? Lori didn't have those either. I mean, this is fairly common. I see it all the time. Okay. So no written daily time records. Most of you realize both of those things are big no-nos, right? We need to have these things. Okay. So when I sat down to calculate the exposure, then it wasn't pretty, right? Silly things that can be avoided, right? Rest period penalties, $7,000. Another $7,000 in meal period penalties, $2,550 in itemized wage statement violations of all things, another $2,800 in waiting time penalty. What's that for, right? So if you add that all up, it's about $19,000 for the one employee. Okay, so that's not too earth-shattering, right? I mean, it's money, it's a significant amount of money, but it's not enough, I don't think, to break any of your banks or put any of you out of business. Okay. But don't forget, this is a class action. And again, much to my surprise, California employers have not heard of these things. Class actions or PAGA lawsuits. I just had a client this week, 170 employees. First time they're hearing about a wage and hour class action or PAGA action. Okay, so what it is, of course, one employee can sue on behalf of all the rest of the employees, whether they like it or not, right? They don't want to be involved, too bad, they're involved. Okay, so, what it is numbers. So what turns, Lori is realizing she's not looking at just one employee for $19,000. She's looking at 19,000 times 85 of the employees who rolled through Lori's businesses during the 4-year statute of limitations period. So it's 19 times 85 or 1.6 million. Okay. So Lori's hearing this for the first time. Imagine the surprise. I mean, 19,000 was bad enough, and now 1.6 million, right? She's really upset. She's shooting the messenger, me, and at one point she says, hey, why does California law only care about employees? What about us small business owners? And then she cried, quite literally. And it wasn't fair and it wasn't right. And I agree with all Loris of the world, right? I call it legalized extortion. It's not fair and it's not right. But it is crazy California law. Okay. So when I sat down with Lori, I told her, look, Lori, you should, try and settle this case right away and hope that they, on a one-on-one basis, and hope that they dismiss the class allegations. Okay. So the whole thing goes away. You could go about your business. So I picked up the phone. I called up opposing counsel. Their opening demand for the one employee is $80,000. Ridiculous. So I knew this wasn't going to go over well with Lori. I sat down with her. I said, Lori, hey, because of the risk and your potential exposure. And Lori's like, what risk? I told you, I paid her all her wages. She got all her breaks. What risk? I said, Lori, you don't have certain things you need to have in place. Trust me, you have some risk. Okay. And that risk could cost you up to $1.6 million. Okay. Lori's super frustrated, and I told her, look, you should be prepared to pay up to $20,000 just to settle this thing and make it go away. And like I said, she's frustrated. She can't believe or understand why she should have to pay this employee who she knew got all their wages and all their breaks, right? In her mind, a penny, let alone $20,000. She didn't want to settle. She didn't feel like this employee deserved anything. I'm sure you've all, if you ever get into a situation, you'll feel the same way. It's crazy. Okay. But this is where I have to explain to Lori, what's the alternative? Okay. If you don't settle, cut your losses now, you have to hire my law firm to defend you or some law firm. And then, you end up paying a lot of money to my firm to defend, and litigation is quite time consuming and ultra expensive. It's ridiculous. Okay. I'm trying to warn you all not to hire my law firm to litigate. It's better to prevent the problem in the first place, 100x. So there you have the litigation process up on your screen, items 1 through 5 with time frames attached, money attached. If you add all that up, it's 4+ years of Lori's life, $360,000 of attorney's fees and costs. Lori's speechless now. And I'm imagining those of you on this masterclass, how many can fathom and begin to understand forking over that kind of money just to defend yourself and potentially losing? Okay, so, Lori is facing one of two choices, neither of which are good. One, liquidate her assets, drain all her savings, mortgage her house, keep fighting, and probably lose at least something because she does have risk, right? Or worse, shutter the businesses, shut them down, walk away from it all, and hope that the lawsuit died with it, right? Okay, so this is not just a bad quarter for Lori. This is, I can lose everything, my blood, sweat, and tears of 25 years territory. Okay, and I see that I've got a question. Just like to let you all know that I'll be handling all questions at the end of the masterclass. The questions don't have to be limited to the content of this masterclass. They can be on anything employment and labor law related. Okay, think of it as a free consult. So ask away. We'll get them all answered at the end. Okay, so not a bad. This is like life threatening to the business territory. And check it out. This is before trial, right? What happens if Lori takes the case to trial and loses? She's looking at the estimated 1.6 million potential class action judgment. Because she has to pay the other side's attorney's fees, it's another 500,000. Okay, which is required in these wage and hour cases. You get to pay the other side's fees, and then she's just looking at her own, not just, but looking at her own attorney's bills to the tune of $360,000. So add that all up, it becomes an eye-popping number, right? 2.5 million. What would you do? You don't want to settle that either. This person you knew got paid everything, got all their breaks. This is a frivolous lawsuit. They don't deserve anything. So would you rather settle for $20,000 or be at risk of a $2.5 million loss? Okay, and this is just for a small mom and pop operation with just 20 employees. Okay? But here's the kicker. This is what didn't change for Lori. The fear that this could happen again, right? Lori still didn't have legal systems in place, the point of this masterclass, preventive, right? Measures in place to prevent this from happening again. And why not? I'm her lawyer, right, at this point. Yep, I told Lori on the first few calls on the front end, Lori, we need to fix this stuff. You need accurate time cards. You need policies. I can help you. Okay, has she taken me up on the offer? No, she is not. Can I force her to? I can't. All right, but lucky for you all, you're on this masterclass learning, techniques and tactics to prevent these sort of crazy things from happening in the first place. Okay? So you do what you're supposed to do, or you think you're supposed to do, right? Pay your employees fairly, treat them really well. You work your tail off 60 to 80-hour weeks to build your baby. One employee, just one, can bring your entire world crashing down. And not because you're a bad person. Remember, not because you're a bad person. So the multi-million-dollar question is, how do we prevent this from happening in the first place, right? Well, for most of you, or a lot of small business owners, there's a fork in the road. And most people don't realize they had a choice or take the wrong path without even realizing they had a choice. They do the left path, they react. You assume best intentions will protect them. They hire a lawyer only when they need one. And then they end up spending hundreds of thousands of dollars, if not millions, but after the damage is done. They lose sleep. They lose money. And they spend, like Lori did, 4.5 years of their life litigating a lawsuit that absolutely could have been prevented. Okay, and spending $360,000 of their hard-earned savings to boot. Well, how about the right path? Okay, smart business owners set up legal protection before they need it. They build their legal HR infrastructure up front. That way, when a problem arises, they crush it before it becomes a crisis. They spend a fraction on the front end and save hundreds of thousands, if not millions, in the back end. Because, as you've probably heard, it's not about, I hate to say it, but not about how much you pay your lawyer, right? It's about when. And for those who set up legal HR infrastructure up front, they're the ones who end up spending $20,000, okay, not zero, but $20,000, a relatively modest amount, instead of $360,000 when the lawsuit hits. Okay, and so let me show you what this looks like when you take the right path. Okay, now I get to tell you about the dream scenario story, right? Our client, we'll call him Bill, owned and operated a couple of bakeries and a food service company. And in any given time, Bill employed about 80 employees on a regular basis, about 250 during a 4-year statute of limitations period. So a little bit bigger than Lori's company. Okay. Before Bill came to us, he had been sued several times. And he had paid off what he called these, quote, frivolous lawsuits, end quote, just to make them disappear and make them go away. Excuse me. But when Bill came to us, he was done. He told me, Scott, I'm done forking over my hard-earned money to pay off frivolous lawsuits, disgruntled former employees, they're greedy plaintiffs' attorneys. He said, Scott, I don't know what's going on, but I've been in business a long time. But in the last 5 or 10 years, I feel like every time I go to fire an employee, they're going to be disgruntled and I'm going to get sued. I told Bill, I said, Bill, this has been happening a lot longer than that. Okay. Fortunately, you're only, it's not fortunate, but you're experiencing it. Okay. But the best we can do, Bill, is help you reduce your overall exposure and your risk. Okay. I call it HR infrastructure. And so we put in place for Bill, right, an employee handbook with wage and hour policies of the nature we've been talking about. Okay. We had all of Bill's employees sign an arbitration agreement with a class action waiver and a PAGA waiver in it. Okay. And so 2 years go by. Okay. What happened? Out of the blue, Bill gets served with a class action PAGA lawsuit. I hate to say it, but it's just a matter of time to any business in this crazy state, sunny state of California. Okay. But here's what Bill did. Total potential exposure, 5 million now, 5 million. But here's what Bill did differently. Bill went from that $5 million exposure to a one-on-one arbitration with a settlement value of less than $20,000. Okay. Instead of spending 4.5 years of his life defending this frivolous lawsuit and forking over $360,000 of his hard-earned money in defense costs to fight it, we were able to shave years off the process and save Bill a substantial amount of attorney's fees and costs. The total savings, if you think about it this way, the $5 million exposure that otherwise could have been less the value of the settlement, so less $20,000 savings, and hundreds of thousands of dollars of attorney's fees and costs. Okay, but here was the emotional shift for Bill. Bill went from stressed, reactive, and bleeding red, right, to having us file a petition to come out arbitration, where we forced the employee to sue Bill in arbitration on a one-on-one basis only, and not as a representative. Numbers, remember, not as a representative of the class action or the PAGA action. So that one, and really it is simple step of having legal HR infrastructure in place, allow Bill to be calm and in control, right? he could go about his day-to-day business without that pit in his stomach every time he went to fire an employee, because he knew that if any disgruntled employee tried to sue him, guess what? They'd hit a wall, right? So that's what it looks like. Much better story when you take the right path, right? Same industry, same legal risk, same crazy California law, and yet dramatically different result. So enough of the stories, right? How do we do this easy, so-called easy legal HR infrastructure, right? It's really 3 steps. Okay, 3 steps, simple steps. Step number 1, you need rock solid written policies on the wage and hour law we've been talking about. You need accurate daily time records that your employees fill out and accurate pay stubs. Okay, and this is a step, I continue to see it, trust me, that California employers continue to miss. Quite frankly, it's why they lose. Okay, super easy fix. You get either through your lawyer. I wouldn't recommend just AI. You need to have a lawyer review this sort of stuff. But custom employee handbook that, among other things, right, contains 4 written policies for your non-exempt employees. You're going to have all your employees, current and future, sign off on this handbook. Okay, and there's 4 policies, wage and hour policies, among other things. 1, timekeeping policy that requires your employees to record all their actual hours worked. No more, no less. The policy will say working off the clock is strictly prohibited. Simple, right? Next policy, you have a rest period policy that gives them 10 minutes paid rest time fully off duty for every 4 hours work or major fraction thereof. Third, a meal period policy, minimum 30 minutes unpaid, fully off duty, free to leave the premises for every 5 hours work. And then, of course, you need overtime and double time policy in compliance with California law. Then you need something that Lori skipped over, right? Accurate daily time records prepared by your employees. It's our responsibility to have accurate time records, but we delegate that to our employees. Okay? So what we need to do these days is an electronic timekeeping system now. Electronic, not handwritten, not calendar, not scheduled like in Lori's case, not text. I've seen all these things, right? An electronic timekeeping system that records time. The technology is there. Technology is there. Records the time to the second, which, by the way, this is where California law is going. Technology is there. Record all actual hours worked. Okay, and then what you're going to do is every pay period, you're going to audit those daily time records against the pay stub. The information has to flow through, obviously, right? Okay, what you're looking for on the time record for every 8 hours work, every shift basically, is 4 punches, right? Punch 1 is in for the day. 2 is out for the meal period, critical. 3 is back in from the meal period. 4, it's out for the day. So 4 punches, absolutely critical, right? And for those meal periods, you're looking for them to last at least 30 minutes, not 27, not 29, at least 30 minutes. And they have to start on the punch card, right? Time clock, no later than 5 hours into the shift. Okay? And then, once you do those things, you have step 1 of your legal shield in place. Step 1 only. There's 2 and 3 coming. Okay? So next time somebody comes to you at this point and says, hey, I didn't get my rest periods. Yep, I'm going to get to the questions at the very end. I worked off the clock and now you owe me overtime. You guys may have heard this before. Or I've worked through my meal period and now you owe me overtime, right? Here's what you do. You show them the handbook policies, friendly reminder. You show them their signature on the employee handbook acknowledgement, the fun part. Give them their accurate daily time records and their accurate pay stubs. Because without these things, California law says you're toast. You lose pretty much. But with these things, like Bill, you shut down frivolous lawsuits. I promise. Okay, step 2 in the process. You need a state-of-the-art arbitration agreement with the rock-solid class action waiver and a rock-solid PAGA waiver in it. What some of you may not realize right now is under the law, state and federal, employers can force now their employees to sign binding arbitration agreements, which compels them to sue their employer in arbitration on a one-on-one basis only. The class allegations will get dismissed with the class action waiver, And the PAGA waiver will stay the action in court pending what? Pending resolution of the private solo one-on-one binding arbitration between you and your one employee, not 250. Okay. And when you win, okay, sorry, my ethics rules prohibit me from guaranteeing any win. Okay. But look, if you follow these 3 steps, step 3 coming up, right, then you're in the best possible position to win, which is what I'm here to do, and you should win. Okay. Hire us. We're happy to defend you. Okay. Because it's simple at this point. Okay. Then what happens is employee's going to get nothing, right? If you win, there is no class action, anything. The PAGA representative component in court will get dismissed. Poof, the whole thing's done. It's gone. There's no them dragging 250 of their unwilling coworkers into the fray. They can't turn a single $19,000 claim into a $5 million 250 employee class action PAGA action. Okay, and here's the monumental shift, right? You take away their greatest point of leverage with this HR infrastructure stuff. It's numbers, right? So instead of 250, it's only 1. And you go from $5 million of exposure to something worth less than $20,000. Okay? A third step in the process. You need a knowledgeable and experienced employment and labor law lawyer in your back pocket. That way, when an issue arises, whether it's a termination issue, a leave issue, maybe you've got entitled employees, or guess what? Just had this conversation this week. The boss, the owner, feels like they're walking on eggshells in their own business. Okay, I hear it all the time. All you need to do is pick up the phone, call us. We're there for you in real time. We give you real legal advice to nip these problems in the bud before they ever become lawsuits. Okay, like I said, once you've been sued, you've already lost. So name of the game is prevention. And the more you use our day-to-day preventive employment and labor law advice, the more rock solid step 1, the HR infra of the HR infrastructure becomes, the handbook policies, and step 2, the arbitration agreement becomes. The more confident you get in managing your workforce, the less mistakes you make. And that's what keeps you from writing $300,000 settlement checks. Okay, but what's the difference between this and paying your average, HR infrastructure, between that and paying your average lawyer a $15,000 retainer, right? Well, most legal advice, including mine, 95% of the time, treats only symptoms. Problems have happened already, symptoms after the fact. Okay, but with this legal HR infrastructure in place, you build legal immunity. Okay, but here's the thing though. Most people will stay stuck in the reactive path. They'll assume best intentions protect them. They think it's not going to happen to me. Okay, and when it does, they scramble, they panic, they pay whatever it takes to make it go away. And that's what results in them paying cutting $300,000 settlement checks. Okay, but our best clients, they make one decision differently. They build their legal HR infrastructure upfront, right? Preventive. They don't wait for the lawsuit to knock on their door. They spend a fraction on the front end and save hundreds of thousands, if not millions, on the back end. Okay. And here's what it looks like over time. So you have a graphic up there. The orangey red line that goes in terms of quarters, left to right, quarters 1 through 13, dollars 0 to 400,000. So the long line is increasing over time and increasing in your out-of-pocket costs, your hard-earned money, right? Those folks, they're reactive. They're constantly putting out fires, right? They end up, cutting checks to their lawyers. But again, after the damage is done, right? What about that short path, the short green one that goes from 0, 1 quarter, but ends abruptly, right? After a few months, okay? They're calm. They're protected. They're in control, right? They spend a fraction of what the reactive business owner spends because they've dealt with the problem already up front, okay? One path, the long one, orangey red, leads to 6-figure settlements, years, trust me, years of sleepless nights and misery in the form of litigation defense, dealing with your lawyers, okay? And the other one, the short path, leads to quick resolutions and peace of mind, right? So obviously, which one is the right path, okay? Your choice. So time for a quick poll. Sort of a rhetorical question, right? Who here sees the value of protecting their business, right? Again, rhetorical question. So what does this mean for you personally, though? Okay, so I'd like to invite you with a free legal strategy call with me personally. Okay, this will be a working session where we map out your exposure, look at your vulnerabilities, and build a custom legal plan to eliminate your employee wage and hour lawsuit risk. Okay, you'll walk away with total clarity on what's leaving you exposed right now and what to do about it. So you pay most law firms, not mine, but most law firms, a $7,500 retainer just for this one call, right? But if you were to spend a little bit of time with me, and you were able to avoid at least one employee wage and hour lawsuit, that would be worth it now, wouldn't it? Okay, those of you who recognize that, that's a leading question, all right? But so you're ready to book your free strategy call with me now, right? So there's two ways to do it. One is you click on that QR code on your screen, or you can also click on the button, okay? It'll take you to my calendar and book whatever time works for you this week or next, okay? And when you book your call, you'll get a couple of free bonuses for immediate download. Bonus number one, it's up there on your screen, our top 10 employee lawsuits report and how to avoid them. Prevention. Second is the 10 biggest mistakes businesses make in choosing somebody like me, their employment and labor lawyer. So go ahead and scan the code, click on the button, book your call, get your free downloads, okay? All right, so there's two kinds of, as you're gathering, business owners, right? Savvy business owners who are proactive, they prepare up front. And then there's sloppy business owners who wait till it's too late, okay? I don't have to tell you, of course, which one you want to be. Here's the thing, though. There's only a few spots available. They tend to go quickly. So, if you're really serious about reducing your legal exposure before the lawsuit hits, then book your call with me. Let's get you taken care of, okay? Now, we'll come back to the screen so that you can book your call, but I'd like to leave you with one final thought. Okay, you all have a choice to make today. Either keep doing what you're doing, hoping that best intentions protect you, waiting for something to go wrong, and then paying $360,000 to your lawyers, right, to clean up the mess and still have other potential exposure. Or you can take the proactive path, the right path, right? Legal HR infrastructure. Call me. Let's put it in place so that you can avoid this pain down the line. And again, unfortunately, it's inevitable in this state. If you haven't been sued yet on this wage and hour stuff, it's only a matter of time. So you best be prepared. Okay, so that's all I have. Before I say my thank yous, I just want to remind everybody that I will stick around to the end to answer any and all questions. Again, not limited just to the content of this webinar, but anything employment and labor law related, think of it as a free consultation. So I know your time's valuable. Thank you very much for your attention. It's been my privilege to present this masterclass, and I hope, if anything, you've learned a few things here to keep yourselves all out of trouble. Okay? Well, thank you very much. And like I said, I'll stick around to answer all the questions. So, and by the way, there it is up on your screen. Click the QR code, click on the button to book your calls. All right, so Q and answer. Okay, one question is just a comment. Julian asks, what about EPLI? All right. Okay, so EPLI, some of you may be familiar with that. What that stands for is Employment Practices Liability Insurance, EPLI for short. Okay, and it's available, it's out there. Okay, but EPLI is mainly designed to protect your employee lawsuit risk in the form of wrongful termination and harassment, retaliation, that kind of stuff. In my experience, EPLI policies do one of a few things relating to wage and hour matters or claims. Okay, one, they don't give you any coverage, no coverage at all, total exclusion on these sort of claims we've been talking about, which is a good point of why it makes it so dangerous, right? And sure, good thought. Let's get EPLI to cover the risk. Well, you can't, because Most policies don't even cover it. And then you have some policies who cover only the defense component and only to a certain amount, a cap. Okay, like say 100,000 of attorney's fees, which is a good deal. Okay, but these things can cost you way more than that, and there's no indemnity. So, you know, if you have EPLI that covers defense costs up to $100,000, guess what? You blow through the $100,000, then you're out of pocket to pay for the defense costs after that, and you're exposed to this like 1.6 million in Lori's case potential class action judgment, no coverage. So EPLI is not a satisfactory result or solution to wage and hour claims. Really, you need the only solution, in my experience, is you got to prevent it in the first place. You need your handbook in place. You need those rock solid policies. You need an arbitration agreement with a class action waiver and a PAGA waiver in it. And then you need good counsel who knows how to use this stuff to shut down these frivolous lawsuits early. So that's EPLI. Okay, Julian also asks a question. Any software you recommend to help with that is ours from Paychex doesn't prevent it. Okay, no disparaging Paychex or ADP. But look, I get it. And I don't have any specific solutions off the top of my head. I'd have to go look them up. I have like a database of running apps that I think, and I just don't remember the names, but I think would do the trick, that are focused on California law, because that's the other trick, right? Overtime and double time under California law. It's tricky. Okay, but they're out there. So you just have to look, right? Just the outcome has to be, look, it just records time to the second. Okay. It allows unlimited punches. So in for the day, out for the meal period, back from the meal period, out for the day. If they leave to the doctor's appointment, they clock out again, clock back in later, and then they click out for the day. So it just needs to be able to handle multiple ins and outs during a work day. It has to be able to calculate daily and weekly overtime properly, and double time as the case may be. They're out there. The technology is there. Okay, Esther has a question. If an employee needs their recorded hours adjusted because they forgot to clock out at the end of their shift, etc., is there a recommended way to make that change without potentially appearing to manipulate hours? Absolutely, great question. So whenever we have to, and it happens, right? We want to try and get our employees into the good habit of near 100% accuracy in terms of punching. Okay, that's not going to happen, right? We all know that. But we get as close to 100% as possible. And then for the inadvertent, forgot to clock out for the meal period, forgot to clock back in for the meal period, forgot to clock in for the day or out for the day or whatever, never as management or the owner do you just, quote, like manipulate the hours yourself, change it. Never. What we need to do is sit down with the employee in real time, which is why you want to audit your time records every pay stub so you can catch these things in real time. And when they miss a punch or two, you call them in and say, look, you missed a punch or two. What happened? And then they explain, they go, oh yeah, I forgot to clock out, but I really did clock out at 5:02. Then what you have to do is document this, have a prefabricated form for every error. You put the date, the time, the correction, and there's a space and a date for the employee to sign off on this correction form. You sign off it as well, and you keep it saved away in a tidy folder that just won't go disappearing at some point, so that if and when you need it, you need it. But note that just the practice of doing it this way, once opposing counsel becomes aware that's how you've done it, then they know there's no manipulating of the time records. And so they're not as hot on the trail of, hey, missed punches, so you're not accurately recording the hours worked. Okay, that's the way to do it, is you need the employee's input, and it's got to be a joint effort. Okay, next question. Sure, one is just a thank you. Yeah, absolutely, my pleasure. Happy to help out. This is what I said, 30 years trying to avoid, try to get my clients to be preventive, right? Be proactive. And like only 5% of the business owners out there are trying to avoid the problem, right? Most of our clients come in only after there's a problem, sadly enough, right? Okay, Brian asked, there was a lot of talk about hourly workers, how to better defense against salary or higher compensated people that may not sign a severance agreement. Okay, so there's a couple of pieces to the question, but since this is a masterclass on wage and hour issues mainly, let me address this issue of salaried, exempt, or higher compensated people when it comes to this wage and hour stuff. If we have, and this is a big if, employee that's properly classified as exempt, right? Administrative exempt, executive exempt, or professional exempt. Okay. And I'm not going to get into the detailed rules under state or federal law of what makes somebody exempt versus non-exempt. And just because they're paid a salary does not automatically make them exempt. But let's talk about that. Let's say they are paid a salary and they are exempt. Then you don't have to worry about any of this stuff. No timekeeping. Don't worry about the rest periods. Don't worry about the meal periods. Exempt employees come and go as they please. They have autonomy as to their time. We only pay them to get the results, right? Like run the company, your general manager. We don't track time or track any of this stuff for them. Okay, it goes out the window. But then the question asks, what happens if they don't sign a separate severance agreement? Well, I mean, then, I don't always recommend a severance agreement. For example, a severance agreement is something that you say, hey, we're going to pay you something extra, some extra money. In exchange for that, you're going to give me a release of all claims, and you give me a promise not to sue, probably give me strict confidentiality, among other things. Okay? So I only recommend that when I detect that there's a red flag situation where it doesn't have to be a high-paid executive. It can be a $15, 50 cents an hour employee, but they're red flag, right? They've been causing you problems for years. And you know in your heart that once you terminate, they're going to sue you anyway. All right? So basically, because this is a double-edged sword, we offer them a severance package. We'll pay you $5,000. You give us release of all claims so you can't sue us, right? So that's a good thing if they sign it. And therein lies the double-edged sword. That's only if they sign it. If they don't sign it, they want to take it. You have to let them take it with them. They go talk to a lawyer. And next thing you know, the lawyer is talking them into a lawsuit and saying, hey, don't sign this thing. Let's sue them instead. So that's the double-edged sword, right? It can be very helpful if we can actually get the employee to sign it. And then we're done. You can sleep well at night knowing that they can't sue you. The odds are very high. They're not going to even try. And even if they do, then we can shut the case down. I've been doing this 30 years, probably thousands of these things, settlements or severance agreements with the release. Only once did somebody try to bring a lawsuit. And of course, we shut it down. So hopefully that answers the question for Brian. But if not, Brian, go ahead and ask a follow-up clarifying question, okay? I'm still here. All right, well, that's the end of the questions that are in existence, but I'm still here. If anybody's thinking of, a burning employment and labor law question that they've been dying to ask a knowledgeable and experienced employment and labor law lawyer, ask away, okay? This is all for you guys. Okay, looks like there's no other questions. So once again, I thank you so much for your time because it's valuable as business owners. I know that. I'm a business guy myself. But if you want to book your call with me, QR code is still up there on your screen if you haven't already. And or you can click on the button to book. Whew. Okay, all. Then that will conclude today's webinar. Thank you once again for your time. Have a great rest of your day.